Good afternoon, everyone. Welcome on behalf of my Court of Appeals colleagues who are seated before you. Welcome to our Law Day celebration. Law Day invariably is such a beautiful day, isn't it? And what a pleasure it is to celebrate with all of you and the noisemakers across on the steps of the Capitol. First and foremost, our thanks to the Albany High School Select Choir, to their director, Mary Leonard. Thank you so much for being here. When American Bar Association members this year gathered to choose a theme for National Law Day, I can't imagine that there was a bit of debate. The choice was so obvious. Law Day celebrates our nation's great heritage of liberty and justice and equality under law. What better example, what better subject could there possibly be than the 50th anniversary of one of our nation's landmarks, Brown against Board of Education, a unanimous opinion of the United States Supreme Court, barely 10 pages long. Brown changed the course of America by inspiring the civil rights movement and significant advance toward racial equality. But in truth, speaking about Brown presents a decided difficulty. So much has already been said over the past century, and most especially in the last few months, as we prepare for the golden anniversary on May 17. Yet remarkably, as we tell and retell the story, still we continue to learn something new. Surely I do. So I'd like to spend my few minutes here today telling you a few of the new things I've learned lately about Brown, in the hope that they reveal something new for you too. Before this year, I had not fully appreciated the brilliant legal strategy that ultimately culminated in Brown against Board of Education. Dedicated, patient, persevering lawyers inspired by Charles Hamilton Houston actually began implementing their visionary plan in the 1930s, recognizing that the courts presented the best option for achieving social justice. Houston saw that a head-on challenge to the separate but equal doctrine of Plessy against Ferguson would not likely succeed, given how entrenched segregation was, especially in the South. And his idea instead was to challenge the separate educational facilities for blacks as unequal. He knew that genuinely equal facilities would be so expensive that ultimately the entire notion of separate but equal would have to give way. The first challenge was in Maryland, where Houston enlisted the help of a brand new lawyer named Thurgood Marshall. The University of Maryland Law School had refused to admit a black student on the basis of race, and there was no separate but equal law school in Maryland for him to attend. As a result of the lawsuit, the University of Maryland Law School was compelled to open its doors to Donald Murray. And then came Missouri. In Missouri, the state offered to reimburse the tuition of a black law student, Lloyd Gaines, in a neighboring state, instead of allowing him into Missouri's own law school. Not equal, said the United States Supreme Court. And then came Oklahoma. Oklahoma allowed a black doctoral candidate, George McLaurin, to attend the state university there, but had him sit out in the hallway apart from the rest of the class, or sit at his own table in the library and the cafeteria. Again, the Supreme Court said, not equal. And then came Texas, when Texas quickly set up an entire black law school just to accommodate a single student, Heman Sweat. The United States Supreme Court again rejected the effort as failing to provide substantially equal education. The disparity was just too great. And then finally came Brown against Board of Education, a head-on challenge to the constitutionality of the separate but equal doctrine. But even Brown had its own twists and turns. After argument in the Supreme Court in 1952, the court requested further briefing and argument on 5 questions. But before the re-argument was heard, the Chief Justice, Fred Vinson, passed away, replaced by Chief Justice Earl Warren. Warren understood the vital importance of a unanimous court and even visited his colleague, Justice Robert Jackson, in the hospital after a heart attack to discuss the first draft of the Brown opinion. The heart attack came first. Chief Justice Warren's opinion became the opinion of the court, unanimously declaring, and this is a quote from that eloquent opinion, that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities inherently are unequal. The idea of gradually chipping away at Plessy against Ferguson had finally triumphed, although choosing a successful strategy was certainly not the only problem confronting the lawyers who walked that 2-decade-long road to the steps of the United States Supreme Court. Thurgood Marshall was nearly lynched in Tennessee and told none too politely in Louisiana by a man with a large gun that he had to leave town before sundown. And the plaintiffs themselves displayed unbelievable, incredible courage. The fact is that Brown never would have happened without families that were willing to fight the odds and take the risks, knowing the wrath they would endure for the right to first-class citizenship and a place in an integrated school. They faced economic boycotts. They faced job losses and denial of credit. They faced removal from land they had sharecropped for decades. They faced threats of violence. A minister in South Carolina who helped bring one of the cases in Brown had his church burned to the ground. All in all, a truly remarkable story, well worth telling and retelling, especially on a day that we honor the rule of law and our great heritage of equality under law. So for the past, and especially for the future, here are my 5 themes from the remarkable story of Brown against Board of Education. First, how fortunate we are, all of us, that throughout history, people have been willing to lay down their lives in defense of our liberty and our ideals. That includes courageous plaintiffs in civil rights litigation. We owe them a great debt of gratitude. And second, how amazing it is, how inspiring it is that a few dedicated, patient, persevering lawyers, despite unbelievable odds, were able to change the face of America. And surely that remains true to this very day as dedicated and patient and persevering lawyers continue to battle injustice to secure our nation's ideals. And third, isn't this also an occasion for a tip of the hat to the 9 justices of the United States Supreme Court who swallowed hard, some of them undoubtedly a lot harder than others, so that they could speak as one, a unanimous court. More than ever, I admire the wisdom of those jurists. Their decision on the merits, to be sure, but important too, the unadorned and imperative tone of their unanimous clarion call for justice. Clarity, simplicity, unanimity mattered enormously on May 17, 1954. And fourth, especially in the years immediately following Brown, I well remember myself, critics insisting, and this is a quote, again and again, the law can't change people. The law can't change people. Well, what do you know? It can. Plainly, the law can change people. The law can change attitudes, and Brown proved that, didn't it? But we also know that the mandate of Brown is not a self-fulfilling prophecy. Still, we need courageous plaintiffs, and we need dedicated lawyers and wise and conscientious judges and caring citizens to change attitudes, to assure that our nation's ideals remain a day-to-day reality. And fifth and finally, celebrating Brown, telling and retelling the story again and again, reminds us of the importance of the rule of law, no doubt of it. Throughout the history of this great nation, the rule of law we honor on Law Day has proved that it is the most effective guarantor of a free and peaceful society, and for the future, it remains the most effective weapon against those who would dishonor it. And I thank you so much. I suspect those were not the words to that music that's playing in the background. Before presenting the Lieutenant Governor, I'd like to introduce a couple of special people in the audience. They're seated to my left toward the back. The Robert Jackson Center and the New York State Bar Association Law, Youth, and Citizenship Program this year conducted an essay contest on Brown against Board of Education for high school students. And we're so fortunate that today we have 3 of the winners with us, as well as the executive director of the program. So I'd like to ask them please to stand and accept your congratulations. Megan Sherlock of Cicero North Syracuse High School, Anne-Marie McLean of Highland High School, and Maxine Vales of John Dewey High School. Thank you so much. And would your director please stand as well? Thank you. And with that, and with apology for the background music, I'd like to call on our phenomenal Lieutenant Governor, Judge Mary O'Donoghue.
Good afternoon, and thank you for joining us. Thank you also, Judge Kay, for inviting me once again to be here on behalf of the state. It's always a pleasure to join you on Law Day, to join our judges in the Court of Appeals, Attorney General Spitzer, New York State Bar Association President A. Thomas Levin, Judge Lippman, and all gathered here for this celebration. With my background, with you, will always be my colleagues, I won't say my former colleagues in the bench and bar. It's always a special day to see you and to join together to remember the spirit and the impact of the law. As in the past, I am here today to set the stage for discussions to follow, and yes, to challenge opinions and to provoke debate on the topic of the day. For those who remember the days prior to the Brown decision and the years of the civil rights movement which followed, 50 years undoubtedly seem like yesterday. And taken in context, as a nation with a history spanning well over 2 centuries, it is indeed only yesterday. Still, many of our family members can well remember living during very different, and for some, very difficult times. But for those born after the civil rights movement, and I say this as a former teacher, we must not only learn about the Brown decision, but learn from it. A discussion about the Brown decision could take us down many different legal, philosophical, and historical paths. But today, we are here to discuss just one of those paths, to win equity by law. One of the myriad reasons that our nation was divided during the Civil War concerned bringing the oppressed in our country closer to being treated as equals. After our victory in that war, the 14th Amendment to our United States Constitution was adopted to create equal protection under the law for all of our country's citizens, regardless of color. Unfortunately, what soon became clearly evident was that equity could not be won by either victory in war or by the adoption of a new law. The American consciousness had to change as well. Across the nation during the Reconstruction years following the Civil War and all the way up to the 1950s, the 14th Amendment was in effect to provide equal protection under the law. Nonetheless, it would be a complete stretch to say that those liberated former slaves and their descendants enjoyed equity in their daily lives. No degree of shame and no degree of embarrassment would be sufficient in describing what existed in that time period. Though no longer divided by war, our country was literally divided along black and white lines. Separate restaurants, separate entrances, separate schools for blacks and whites existed and were considered acceptable. Even the United States Supreme Court reflected this shameful attitude in its 1896 decision in Plessy v. Ferguson, holding separate but equal. Thankfully, roughly 50 years later, it was our United States Supreme Court which was on the forefront of changing the American consciousness in the Brown decision. In Plessy v. Ferguson, the Supreme Court held that separate was equal. This was the American attitude of the day, just as 100 years prior, when slavery itself was considered an acceptable way of life. The Brown decision, however, overturned years of the separate but equal doctrine. As written by the court in the Brown decision, and I quote, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." It was this important change which forever changed the face of American culture and American society, because it is truly with education that people improve themselves, that people create expanded opportunities in their lives. All of us present today know the importance of education and have benefited from our own schooling. Today, we have the unique perspective of looking back 50 years later. What do we have to show from the Brown decision, and what have we learned? We have a broad spectrum of people represented now in every aspect of life, from government leaders to captains of industry. Many of those people who make decisions today are the same people who were oppressed by slavery 200 years ago and were treated less than equal during the years leading up to and even following the Brown decision. It is pivotal to recognize that we cannot be happy with just that. We must not be happy with just that. Our ever-evolving American consciousness will not allow us to be content with those accomplishments alone. We must continue to work together to overcome our own shortcomings as a nation today. That is why today, wherever it is recognized that there continues to be a divide among our people as good citizens, we all have an obligation to bridge these divides, or better still, to eliminate them. As the leaders of New York State, we have and will continue to work toward that goal. As in the Brown decision, it is up to the leaders, to the advocates, and our courts to guide us. But whatever additional laws are changed or created by the legislature, or whatever court decisions are held, we must take our lessons from Brown and realize that a change in our laws is not enough. A change in our collective attitude is paramount in bringing about the necessary changes in every aspect of life to ensure equity for all. This lesson from Brown should never be forgotten. Just as equity cannot be won by law, nor can it be won by brute strength. A change in a law or a victory in battle can only provide a point from which to start. The popular opinions which enable us to make changes in the law are never unanimous opinions. That's my emphasis, and that's my most important point, so I appreciate that. They're never unanimous opinions. Therefore, equity will only be won by changing the collective consciousness of our citizenry. We will continue to fight to ensure equity for all, regardless of the color of one's skin or the neighborhood in which one lives. Best wishes for your success in these very important endeavors.
Thank you so much, Lieutenant Governor Donahue, for that terrific message and important challenge. I was not going to introduce anyone from the audience. It's such a dangerous thing to do, but there is one utterly irresistible introduction I must make, and that is our phenomenal presiding justice, Anthony Cardona, and the court. Next, I would like to present our Attorney General, the Honorable Eliot Spitzer, for his Law Day message. And Eliot, I've asked them to play your song in the background.
Thank you, Judge Kaye. I will hold you accountable for whatever they play. This is my 6th year as Attorney General, but I have delivered only 5 Law Day speeches. I'm sure you were delighted last year to have heard Caitlin Halligan, New York's incomparable Solicitor General, speak on behalf of the Department of Law. I want to thank her for not only covering for me last year, but for representing the department day in and day out, as do all the extraordinary lawyers in my office with whom I have the privilege of working. Caitlin, thank you. It is always an honor to join the distinguished members of a court that sets the highest standard of wisdom, spirit, and vigor. Our Law Day celebration is the wellspring where we recommit to the noble pursuit of justice. I like to think we come away renewed and reinvigorated. It's an even greater pleasure now to be at this extraordinary building, and we have to thank Chief Judge Kaye for her vision that this courthouse could both capture the modern era and at the same time be dignified and true to its storied past. Judge Kaye, thank you and congratulations. Today we reiterate the importance of law in society. We acknowledge that the law designs a pathway to the future as it re-examines the past. The law is a dynamic engine that provides the thrust that moves society forward or sideways or backwards. Brown versus Board of Education, as we know it, almost did not happen. In December 1952, after the first oral argument, only 4 justices favored finding school segregation unconstitutional. 2 leaned toward reaffirming Plessy v. Ferguson and the principle of separate but equal, and the 3 others were undecided. Among the undecided were Justices Frankfurter and Jackson. Both abhorred racial segregation, but struggled over whether the 14th Amendment required its demise or whether only Congress could take the lead. After all, at the time, 21 states and the District of Columbia still permitted or required segregated schools, and roughly half the country supported school segregation, which itself had existed for over a century. The same Congress that had passed the 14th Amendment in 1868 had supported school segregation in the District of Columbia, and most of the states ratifying the 14th Amendment had segregated their schools. If these justices now acted on their personal feelings against segregation, how were they any better than the now discredited justices of the Lochner Court, who had read their own economic biases into the Constitution to strike down public health and minimum wage legislation? As one of Justice Jackson's law clerks told him, the question in Brown was whether this court would differ from the Lochner Court only by the kinds of litigants it favors and the kinds of special claims it protects. Then, in September 1953, Chief Justice Vinson, who had leaned towards Plessy, suddenly died. Eisenhower appointed Earl Warren as Chief Justice. That December, after Brown was re-argued, Warren told his new colleagues that the separate but equal doctrine rests on the basic premise that the Negro race is inferior, and that this premise was wrong. Now there was a majority, and Warren moved quickly to make it unanimous. In May 1954, the court announced Brown. Even though the 14th Amendment's legislative history was inconclusive, the court reasoned, separate could never be equal, because separating school children, quote, solely because of their race, generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. While many Americans applauded, some sharply disagreed. One prominent Southern journalist warned, the court had tortured the Constitution. The South will torture the Supreme Court decision. A Mississippi newspaper promised, quote, bloodstains on the white marble steps of the Supreme Court. Meanwhile, the civil rights movement, as we now think of it, was just beginning to unfold. Only 2 weeks earlier, a young reverend named Martin Luther King Jr. had delivered his first sermon as pastor-designate of the Dexter Avenue Baptist Church in Montgomery, Alabama. The bus boycott was still over a year and a half away. Half a century later, Brown stands as a giant of the legal landscape, perhaps second only to Marbury v. Madison. Every lawyer has read it, and many went to school because of it. Because anniversaries are about remembering, I want to give you 5 reasons, not 10, just 5, why we remember Brown and why we should. Reason 5. Brown represents the full bloom of a form of public interest lawyering that has strong roots in New York. Among the 5 attorneys who argued Brown before the Supreme Court, 3, Thurgood Marshall, Robert Carter, and Jack Greenberg, were distinguished members of the New York Bar. In fact, New York's tradition of public interest lawyering goes at least as far back as 1876, when the German Society of New York established a legal aid office to help new immigrants. But it was Charles Hamilton Houston and others at the New York offices of the NAACP who developed the idea of using constitutional law and the courts as a tool for social reform. Today, of course, many organizations across the political spectrum are devoted to litigation as the way to achieve social and political change. But at the same time Brown was decided, this idea was unfamiliar and to some, quite threatening. 10 years later, the Supreme Court affirmed the importance of publicly minded impact litigation. In NAACP versus Button, the court ruled that a Virginia law which prohibited attorneys from accepting cases or compensation from organizations that were not actually parties to the litigation and that had no financial interest in the outcome of the litigation was unconstitutional, as applied to the NAACP. Of course, such a law would effectively have put out of business organizations like the NAACP that sought to use lawsuits as a means of advancing social change by finding and providing representation for litigants whose rights were being violated. Virginia had claimed that the law was merely an exercise of the state's right to regulate the legal profession and legal solicitation. But Justice Brennan, writing for the majority, rejected this contention out of hand. The NAACP's litigation, he wrote, was a form of political expression. More to the point, Brennan concluded the contribution of the NAACP's litigation efforts were essential cogs in the machinery of democracy. He said, the NAACP is not a conventional political party, but the litigation it assists, while serving to vindicate the legal rights of members of the American Negro community, at the same time, and perhaps more importantly, makes possible the distinctive contribution of a minority group to the ideas and beliefs of our society. For such a group, association for litigation may be the most effective form of political association. For us today, Brown stands as the paradigm of how publicly minded lawyers can act as a positive force for social change. Reason 4, Brown reminds us about the central role of public education. It was John Dewey who observed that in both theory and practice, democracy itself is grounded in faith in the potentialities of individuals, faith in the capacity for positive developments if proper conditions are provided. Equal access to public education is essential to this faith, not only because voters need education to make wise decisions, but also because public education attempts to make good on a core promise of democracy, that everyone will have the opportunity to develop his or her potential to the fullest extent possible. Therefore, it was only fitting that Brown, the first blow that the Supreme Court struck against the system of American segregation, was about public education. Reason 3, Brown also stands for the proposition that when the 14th Amendment says equal protection of the laws, it means more than the equality that accountants might require, a mere counting of textbooks or boxes of chalk, a tallying up of rights and privileges in one column, and making sure that they match the rights and privileges in another. Discriminatory laws are offensive not only because they result in some people getting more benefits than others because of their membership in a particular group, but because invidious distinctions themselves create, in the words of Justice Harlan's monumental dissent from Plessy v. Ferguson, and I quote, a badge of servitude wholly inconsistent with the civil freedom and equality before the law established by the Constitution. The majority in Plessy infamously responded to Harlan by arguing that if, quote, the enforced separation of the two races stamps the colored race with a badge of inferiority, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. When Brown rejected that argument, it recognized that the harm discriminatory laws cause to personal dignity is itself a denial of the equal protection of the laws. Reason 2, Brown also teaches that making good on the promise of equality comes with a price. And just as the benefits of equal rights redound to all citizens, so must the cost of redressing historic inequalities be borne by all citizens. In the most basic sense, Brown highlights the unfortunate truth that the price of realizing the promise of the Equal Protection Clause falls upon those courageous foot soldiers who lead its revolutions and who pay physically and emotionally as they lead us forward. A third grader, Linda Brown, and her parents come to mind, as does the legal battle they took on so that she would no longer have to walk 1 mile through a railroad switching yard to get to the bus that would take her to the black elementary school because the white elementary school 7 blocks away would not permit her to attend. Others who paid a heavy price for equality include the 9 Little Rock High School students who bravely faced down the governor of Arkansas's resistance to desegregation at such great peril to their physical safety that the President Eisenhower had to send 1,000 paratroopers and 10,000 National Guardsmen to protect them. And James Meredith, the first African-American student at the University of Mississippi, whose attempt to enroll in college resulted in violent clashes that left 2 people dead. Indeed, during the Freedom Summer of 1964, in Mississippi alone, there were 35 shooting incidents, 30 bombings, 35 churches burned, 80 beatings, and 6 murders. Marchers at Selma and the lunch counter protesters bore fire hoses, police dogs, spit and rage to dismantle an outmoded way of life. These brave individuals and countless others made an immeasurable contribution to our country, and we can never fully repay our debt to them. But Brown's grand vision also exacts costs from those citizens who have not been historically burdened by state-sponsored inequality. The late legal scholar Charles Black made this point elegantly in his defense of the cases outlawing segregation. Black said of the segregationists who decried integration as a threat to their own associational freedoms and their cherished way of life, that if, quote, the directive of equality cannot be followed without displeasing those who would demand the so-called freedom of inequality, then it is that so-called freedom that must be impaired. It is easy, though, for history to enter judgment against those, like the segregationists, who defied Brown by closing swimming pools and parks and the public schools to evade its mandate. More challenging is to fairly allocate the costs of redressing those inequities which remain long after the drafting of the 14th Amendment and the death of Jim Crow. We see the first round of this struggle in Brown's progeny as the Supreme Court struggled with such seemingly semantic distinctions as whether the lower courts were to be instructed to desegregate schools forthwith or with all deliberate speed. We, of course, know that they chose the latter construction, and in the seemingly negligible difference between the two phrases, years of persistent segregation festered. 20 years later, we saw in the Boston busing riots how, when the cost of pluralism hit close to home, when the cost of many people may recoil, feeling that the benefits of equality are not worth its burdens. More recently, last term, we saw the Supreme Court struggle with the challenges to the affirmative action programs employed by the University of Michigan Law School and undergraduate admissions programs. As my office argued in New York's amicus brief to the court on behalf of the university, given the unparalleled importance of education in fostering the democratic values of a pluralist society, affirmative action programs like the one used by the University of Michigan must be held constitutionally permissible. Writing to uphold the law school programs, the court understood that such programs are a cost of redressing what they called our nation's struggle with inequality that must be borne even though we might today feel ourselves distant from the struggle of those students who required federal guards simply to go to school. And finally, reason one, and most relevant to us today. Brown reminds us about the relationship between the promise of equality under the law and the power of judges. Brown dismantled not only segregated public schools, but also separate public parks, separate public swimming pools, and later bans on interracial marriage, because judges took Brown's underlying constitutional principle seriously. When the government treats a people differently solely on the premise that they are an inferior people, that very act of singling these people out alone denies them the equal protection of the laws. Brown reminds us that when judges not only take seriously the guarantee of equality, but also take seriously their duty to enforce that promise, courtrooms become more than battlefields, they become guarantors of justice. The framers, though they themselves failed to perfect the union they were espousing, recognized that this would be the special power of the judiciary. As Alexander Hamilton wrote to the people of New York in Federalist 78, while the executive branch controls the sword and the legislature the purse, the judiciary has only its judgment to wield in protection of our liberty. This might strike us as by itself a relatively weak power. However, the genius of our constitutional design, Hamilton explained, is that the judiciary's power of judgment is buttressed by its independence. That is, its exclusive power to ascertain the meaning of the Constitution and to judge the acts of the coordinate branches without interference. But in wielding this power, judges are obliged to be sentinels of the Constitution and, quote, to guard the rights of individuals from those ill humors which have a tendency to occasion serious oppressions of the minor party in the community. And indeed, we see that both this independence and this vigilance are essential to preserving the vitality of the Constitution as our circumstances change. The great constitutional scholar John Hart Ely observed, quote, the overriding intention of those who wrote and ratified the Equal Protection Clause was apparently to state a general idea whose specific applications would be supplied by posterity. Since they could not instruct us as to what full equality under the Constitution might come to mean, the framers instead bequeathed us a judiciary upon whose independence we rely for definition of this fundamental guarantee. In this respect, Brown shares Hamilton's vision, but its legacy also reminds us that constitutional guarantees of equal protection are no more than ink on parchment, or no more than the aspirations of our founders, unless judges have the courage to enforce them, even when doing so will not be popular. Indeed, in reading Brown today, we are reminded that its work remains undone. For every court decision that is the glorious child of Brown, there were many more, including the Supreme Court's own Brown II, in which judges who feared popular resistance to their decisions fashioned remedies that would soften the blow that equality's uncompromising stand might have inflicted. Hamilton knew that, quote, it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution against the will of the majority. But if we chafe at this majority-checking role of the judiciary as some kind of anti-democratic usurpation, we should remember that this structure actually aids democracy by encouraging the other branches to act on their own to quell any impulse which might run afoul of the Constitution. More importantly, as Hamilton poetically observed, we should welcome the court's fierce protection of constitutional values because, quote, no man can be sure that he may not be tomorrow the victim of a spirit of injustice by which he may be a gainer today. So we should take guidance from those judges as deserving of our praise as the justices who penned Brown, like the four giants of the Fifth Circuit, John Minor Wisdom, Elbert Tuttle, Richard Rives, and John Brown, who deep in the racial thicket of the South actually gave legal meaning to Brown's instruction to proceed with all deliberate speed, and in so doing drove home that a judiciary that strives to faithfully fulfill its obligations will always engender more respect than it does disdain. Thank you very much.
Thank you so much, Attorney General Spitzer, for reminding us of so many of the important lessons of Brown and particularly of the significant work that remains undone. Today, on Law Day, we honor the rule of law, but we also honor the dedicated, patient, and perseverant lawyers who help to safeguard and preserve the rule of law. It is my privilege next to call on a representative of the bar, Thomas Levin, the president of the New York State Bar Association.
Good morning. It's a pleasure to be here today outdoors in this lovely setting, much as I had looked forward to speaking indoors in the courtroom facing the opposite way from what I'm accustomed to. For the next few moments, please join with me in traveling back in time, accompanying some 350 members of the State Bar Association's Young Lawyers section, 15 from Albany and others from around the state, on a journey which they took to Washington for admission to the U.S. Supreme Court. It's not quite as far back as 1954. It's 1958. It's May. It's just 4 days after the nation observed the first Law Day. Taking their place on the bench were Chief Justice Warren and Justices Black, Frankfurter, Burton, Harlan, and Whitaker. And then, in an impromptu talk following the formal admission ceremonies, the Chief Justice gives this counsel to the new admittees. I would have you remember one thing. The Constitution is a written document, which is nothing but something to read until lawyers have the courage to stand up fearlessly in this court and in all other courts for the rights and other things in that document. This comment was made in the true and wonderful tradition of the legal profession, in which we share experience and insight with our colleagues. Perhaps on the minds of those newly admitted lawyers in 1958 was a case decided by that court just 4 years before on another day in May, Brown versus the Board of Education. Perhaps echoing in the courtroom that day were Chief Justice Warren's words for the unanimous court in Brown. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. They would have known, those admittees, of the controversy generated by that ruling, from its content to its approach to the role of the judiciary. Or those 1958 admittees might have been thinking back just 8 months earlier, when the struggles for desegregation of Little Rock Central High School resulted in a federal injunction and the call by President Eisenhower for the National Guard and federal troops to come out, finally to bring about the admission of 9 black students to that school. And they knew that the history of the civil rights movement in the courts did not begin and would not end with Brown. Like most landmark decisions, this case did not occur in a vacuum. Brown represented the perseverance and the courage of numerous citizens, civil rights workers, and members of the legal profession. It was a merger, as we heard earlier, of 5 cases from Kansas, South Carolina, Virginia, Delaware, and the District of Columbia. And it was a chain of cases challenging such areas as separate graduate schools, inequality in teacher salaries, segregated seating on interstate buses, exclusion of blacks from criminal juries, separation within a graduate school classroom, and separate law schools, among others. This evolution of Brown reflects both the challenge and the value of the rule of law. It's incremental. It involves a confluence of constitutional meaning, legal precedent, social mores, changing times, conditions, and needs. And it also illustrates another element of our legal system, the bonds that connect the members of the legal profession as they build on each other's work, setting in place stepping stones and sometimes bridges for justice. Chief Justice Warren told those lawyers at that 1958 ceremony, "You may not have occasion to plead a case before this court this year or next, but do not become fretful. You are now making the fodder." And I believe that we, the bench, the bar, the executive and legislative branches, the individuals and institutions, the individual citizens and all of society can benefit most from our hindsight on the history of Brown. First, we gain from the lessons of Brown by considering this as a case about civil rights in the broadest sense, pursuing equal rights for all, equal protection, including and beyond education, and giving voice and accessibility to the justice system for everyone. Further, we should remember Brown as a matter of taking opportunity, of applying courage when it would have been easier to remain silent or take a more popular stance. Emerson observed that difficult duty is never far off. Therefore, we must think with courage. And he cited the example of the judge who, faced with what seems to be a tangle of contradictions, squarely accosts the question, and by not being afraid of it, is able to see the way to resolution. Thirdly, by the actions and inactions that led to Brown, we can see that these efforts require our continued attention and that each of us has a continuing responsibility for the well-being of our justice system and our democracy. As we celebrate the role of Brown and its predecessors and progeny in making progress in an ongoing journey for civil rights, equal protection, access and opportunity for all, we also must cite the importance of the Civil Rights Act, the Voting Rights Act, and other legislation and executive orders that have followed these milestones and that were integral in advancing this mission. Listen to a voice of the 1960s reflecting on the aftermath of Brown. Majority Leader Mike Mansfield, in the U.S. Senate's 1962 Civil Rights debate, said, "Our recent constitutional history makes it clear that progress toward the equalization in practice of the ideals of human freedom will not be halted indefinitely. When one road to this end fails, another will unfold. If the process is ignored in legislative channels, it will not be blocked in other channels, in the executive branch and in the courts." And in this lesson from history, it's clear that such efforts must be soldered together by the three branches of government along with the bar. In addition to the continued work to advance civil rights, we have opportunities today in other areas to promote access for the citizens of our state. I'd like to take a look at two current examples. First, consider the lawyers and judges who worked for counsel for indigent defendants, ultimately resulting in the 1963 Supreme Court decision in Gideon versus Wainwright that provided for counsel in felony matters. And consider in New York this Court of Appeals determination 2 years later in People versus Witensky that extended counsel to all criminal defendants and determined that the right of counsel must be made meaningful and effective. And this followed in 1965 by legislation which resulted in public defender and assigned counsel programs. Think of the countless lawyers who have brought the words of these decisions and statutes to life by counseling and advocating for poor defendants. They have a partner and a champion of their efforts in the organized bar. The State Bar and other bar associations over the years have been there consistently and vigorously to urge that these programs are viable, adequately funded, and with an adequate pool of lawyers handling reasonable caseloads. We take this strong stand because justice, to be meaningful, to be real, to engender confidence, must be within reach. So notwithstanding the signing of legislation last year that raised the outmoded assigned counsel rates and created an indigent legal defense fund, the Indigent Legal Services Fund, we continue to work for rates at constitutionally acceptable levels that will ensure the provision of counsel for the indigent as envisioned by Gideon, and for procedures to effectively facilitate the provision of those counsel. Ensuring access to the legal process is also the reason for the Bar Association's consistent and concerted work to preserve viable and adequately funded civil legal service programs for those without means. 3 days from now, on May 3rd, the State Bar will salute attorneys from around the state in each judicial district for their exemplary pro bono service. Did you know that members of the New York Bar contribute more than 2 million hours annually of their time and expertise for the voluntary legal services for the indigent? We take this responsibility to act in the public interest very seriously. But these enormous and growing legal needs cannot and should not be shouldered solely by the bar. These problems are societal in nature, and the solutions must come from every element of society. The lawyers can be counted upon to do their part, or more likely, in view of our long traditions in this regard, to do more than their part. Government-funded staffed legal services, supplemented by volunteer lawyers, are essential to consistent and effective counsel of New York's low-income citizens. We're justly proud of the volunteer work of the private bar and of the partnerships that legal services and pro bono programs have forged to maximize resources and facilitate service. Unfortunately, federal funding is significantly lower today than it was 10 years ago, causing cutbacks in many of these programs in triage and serving the poor. And unfortunately as well, the state interest on lawyer account fund has been plagued by declining interest rates, so that the funds available are less than 1/4 of what they were in 1992. This has reduced grants even further. New York ranks near the bottom among all states in funding of legal services. And while some programs have benefited from supplemental state funding, a regularized source of funding is critical to avoid placing programs and people in limbo from year to year, and to avoid the need to expend enormous time searching for extra dollars. This is time and talent that could be focused on untangling legal problems and enabling lives to get back on track. Innovative suggestions have been made, broadening and using money from the Abandoned Property Fund, for example, and positive moves have been made, such as the legislature's designation of the Legal Services Assistance Fund. Earlier this month, we at the State Bar established a special committee on funding for civil legal services to explore some new and key funding sources, including unclaimed funds or undistributed funds earmarked for charitable purposes, and to recommend criteria how legal service funds should be allocated to make sure that the most urgent unmet legal needs of the poor are addressed. It's critical that these funding avenues be brought to life and that adequate supplemental legislative monies be supplied. It's critical to the domestic violence victim and child. It's critical to the elderly couple in a dispute with their landlord. It's critical to the well-being of the communities in which they live. And it's critical that we all do this together. And we also need to recognize another catalyst to having an accessible and effective justice system: the understanding, involvement, and respect of the public. Some here today will vividly recall news coverage in years past of fire hoses being turned on citizens and other actions defying court and executive orders. These shocking scenes, brought by the media into living rooms and onto kitchen tables across America, advanced the call to action to promote civil rights and equality. They helped bring home the concept contained in Governor Averell Harriman's message on the first law day, that we look to the law and the courts to safeguard every person's life and property and to protect the precious freedoms established under our federal and state constitutions. Further, as Governor Harriman observed, in our country, we must recognize that the preservation of equal justice under law is a personal responsibility. So on this 50th anniversary of the Brown decision, on this 46th anniversary of Law Day, let us remember that each incident of discrimination, each situation where the justice system is placed out of the practical reach of anyone, each time a citizen's voice cannot be heard, is one time too many. Let's remember the progress that's been made as a result of the courage of citizens and the actions of government. Let's recall the obstacles that had to be overcome and recommit ourselves to clearing paths, opening doors, and stand shoulder to shoulder to advance the cause of justice. If we do this, we'll fulfill the promise and learn the lessons of Brown versus the Board of Education. If we do this, we'll fulfill the dream of equal justice for all. If we do this, we will do what lawyers do best, defend liberty and pursue justice. Thank you.